I am so pleased to be talking with attorney Tim Kennedy from Hall Render out of the Indianapolis office. And we are going to be hearing his informal observations about the legal aspects of EPM and where we are today. Tim, today is April 19th, and there's a chance that a month from now, things may change. We may be hearing from Washington with some modifications to rules. So with that in mind, what do we know now, and what do you anticipate with what we know?
Sure. Well, with respect to the cardiac-related EPMs, currently the rules that are in place say they will become effective May 20th, and the first performance year of the EPMs will begin October 1st and end December 31st, a 3-month period for the first performance year. It's likely, although there's no guarantees, but it's likely that that 3-month period will be changed, and no one would be surprised if that first performance year was pushed back to January 1st of 2018 and have that first performance year to be a full calendar year. There's also possibilities, and there are all kinds of rumors out there, all kinds of possibilities that there'll be some substantive changes to the current status of the rules themselves. They probably would not want this current rule, if they're going to make changes, to allow it to go into effect and then at some point down the road change it. They would probably, we think, want to make those changes, whatever they may be, if any, before May 20th.
Okay. And so with that degree of uncertainty, and at this point, what do you recommend for programs to plan in advance and prepare for what may happen? Are there certain things that can be done with some certainty at this time?
One of the key components of these EPM models, be it AMI or CABG, is having a written sharing arrangement between a participant hospital and an individual or an entity known as an EPM collaborator. And so for purpose of our discussion, let's assume that collaborator is a physician group. Under the current regulations, and these probably won't be changed, before a hospital can enter into these relationships with physician groups or any other entity that might be an EPM collaborator, the hospital itself has to come up with a list of criteria for what it will look to and how it will judge individuals and entities that might want to be a collaborator with that hospital. And that criteria has to be listed and posted on the hospital's website, and the hospital has to follow those criteria in the course of interviewing, looking at, otherwise discussing the potential for an arrangement with an EPM collaborator, which I think is something that most hospitals and most physician groups aren't aware of, that this sort of work has to be done in advance before they can actually enter into an arrangement. Okay,
and I know you did 2 presentations today or over this conference. One question we heard was what happens after a physician group receives a gain sharing payment? Right.
Well, unfortunately, every aspect of these regulations is complicated, and it's built upon definitions which are built upon other definitions. It's a maze of definitions. But basically, again, let's assume it's a physician group that's the EPM collaborator, and it receives a gain sharing payment from the hospital. There are rules about how that physician group can distribute the gain sharing payment it received from the hospital, how that payment can be distributed amongst the physician group's members itself. It's quite detailed. It requires a specific written agreement, a distribution arrangement, written distribution arrangement between the group and its members. And there are a number of criteria that must be satisfied. And one of the questions we get is, well, if our members are employees of the group, could that employment agreement suffice as a distribution or written distribution arrangement? Unfortunately, no. Unless if for some reason the employment agreement was to include the criteria required for a written distribution arrangement, then that would suffice. But most of the time we're going to have a situation where a written distribution arrangement must be entered into, and it'll be separate and apart from the employment agreement.
Okay. I know that you have worked with MedAxiom to do a series of webinars talking about this, trying to explain, going to the details. So I know our audience will want to stay tuned and learn more. Is there anything else you would recommend in terms of becoming more familiar with the legal aspect of it? Is your website perhaps, or government website where people can go to really start educating themselves?
Well, one of the great resources is MedAxiom's website. They've got the recordings of the prior webinars we've had. They've got other written materials, so I would encourage them to go to the MedAxiom website. If they don't mind reading volumes of legalese from the federal government, look forward to the federal rule, assuming one comes out on or about May 20th. It would be at least know if it gets issued or not, and know that it may, if so, that likely changes are afoot.
And we will be doing, I'm sure, a summary of that rule.
Yes.
When it does come out, as you've done for us in the past, which we so appreciate your insight and expertise in helping us understand this very complex issue.
I've appreciated it very much.
So thank you so much for your time,
Thank you.
and we will look forward to future conversations, I'm sure.
Great, thank you.
Okay.